Hi, and welcome to the webinar. My name is Kim Wilcoxon. I'm a partner in the Thompson Hine Employee Benefits and Executive Compensation Practice Group in Cincinnati, Ohio. I'm delighted to introduce my colleague, Beth Mandel, also a partner in the Cincinnati office. And we have our associate Meredith Kimmelblatt with us today from our Washington, D.C. office. Oops, I forgot to show you these people. Here we are. This is us. You won't see us on the screen today except in these pictures. For the next hour, we are going to talk about practical responses to the final mental health parity regulations. We're going to start with a very, and I emphasize very, high-level overview of the new regulations. We are not intending today to go through the regulations in detail, to tell you what's different between the final regulations and the proposed regulations, or how they, right? We're going to assume that you know what mental health parity is. We're going to assume that you know what NQTLs are. We're going to assume that you know that you're required to have a written NQTL comparative analysis. If you don't know those things, I'd recommend just signing off now, going and reading what you need to read, and then come back and listening to the recording because we're assuming that you all have that background with you. So we'll do a very high overview of what the regulations are doing. Then we're going to talk about in more detail what you need to know for 2025, and that's where we're going to spend the bulk of today's presentation. Then we'll spend some time talking about what you need to know for 2026. Throughout the presentation, we will be identifying action items for employers, but then at the end of each section, we have a consolidated list of action items. So you can sort of look at those slides for a one-stop shop of what you might need to do. Before we begin, a few housekeeping items. Today's program is being recorded. We're going to send a link to all attendees, including the PowerPoint, within 48 hours of today's presentation. If you have any questions during the webinar, please use the question box located in the control panel on the upper right of your screen. We'll answer as many of the questions as we can at the end of the webinar. Thank you for your interest, and now I'm going to turn it over to Meredith to give us a very, emphasize very, high-level overview of the final regulations. Meredith?
Thank you. So as you all probably know, the Departments of Labor, Health and Human Services, and Treasury issued final mental health parity regulations on September 9th. The departments have not yet issued any enforcement fact sheet, any report to Congress, or any self-compliance tool, although we expect them to issue at least the enforcement fact sheet and report to Congress at some point this year.
And the self-compliance tool. We were told last week that we can definitely expect that.
So what do the final regulations do? They finalize and update many of the requirements in the prior proposed rule and provide new standards for how plans evaluate compliance with non-quantitative treatment limits, or NQTLs. They also confirm the content that must be included in plans' written comparative analyses. And most of the requirements are generally effective for plan year 2025, although certain aspects are delayed until 2026. And we're going to get into these in more detail shortly, but just as an overview, here are the key requirements that are new for 2025. First, plans must provide a list of NQTLs to the named fiduciaries of the plan. The regulations specify content requirements for the written comparative analyses, many of which are consistent with prior information and guidance from the Department of Labor. And one new element is the requirement to have a fiduciary certification relating to the process for selecting service providers to perform comparative analyses and monitoring those service providers. The regulations also set forth guidance for determining whether benefits fall under medical, surgical, or mental health substance use disorder classification. And then again, we'll get into these in more detail shortly, but an overview of the requirements that will be effective for plan year 2026. Plans must provide certain coverage for at least one core treatment for each covered mental health or substance use disorder condition, known as the meaningful benefit standard. The factors and evidentiary standards used in the NQTL analyses cannot be discriminatory as of 2026. And plans must also evaluate and obtain outcomes data and take reasonable actions to address material differences in mental health substance use disorder access as compared to medical surgical benefit access. So getting into what we need to know for 2025. As we just referenced, a list of the plan's NQTLs as of plan year 2025 must be provided to the plan's named fiduciaries who are required to make the fiduciary certification we also referenced, and that I think Kim will discuss shortly. The list must also be made available to the Department of Labor upon request. So how do you identify your plan's NQTLs? The Department of Labor has not defined an NQTL expressly, but they have defined treatment limitations to mean both quantitative treatment limits expressed numerically, such as 50 outpatient visits per year, and they've also defined it as non-quantitative treatment limits, or NQTLs, which otherwise limit the scope or duration of benefits for treatment under a plan or coverage. And note that completely excluding all benefits for a particular condition or disorder is not in itself an NQTL. And so the Department of Labor has not provided us with an exhaustive list of NQTLs, but we can glean from the regulations and previously issued self-compliance tools what NQTLs they have identified in the past. So I won't go through the whole list here, but you can see that from the regulations, some of them include medical management standards, formulary design for prescription drugs, network tier design, and then there are 3 additional NQTLs from the self-compliance tool, excluding specific treatments for certain conditions, restrictions on applicable provider billing codes, and standards for providing access to out-of-network providers.
And I'll just add really quickly here that the agencies are very focused on the standards for network composition. And this is important because these types of NQTLs are not going to be readily apparent to you when you are looking through your summary plan description, your benefit booklets. They're not going to get into detail about the standards for network composition. So that's an area where we're really going to have to dig for information from the third-party administrators.
And this will be an area of focus as we talk about the 2026 requirements on data evaluation.
And so this list was pulled from the prior report to Congress, I believe, and it shows that, or sorry, I think that was a different list, but this shows the NQTLs for which the DOL has previously requested comparative analyses, and they're listed from most requested to least requested, and you can see that the bulk of the requests deal with things like prior authorization, pre-certification, or prior notification. Similarly, exclusion of ABA and other behavioral therapies have been frequently requested, and like Beth was saying, network admission standards.
So let's talk now about the required fiduciary certification, which it seems to me that there seems to be this perfect storm around fiduciary compliance for health and welfare plans. So we now have this fiduciary certification. We've seen lawsuits dealing with breach of fiduciary duty for selecting and monitoring PBMs, and certain other things. There just seems to be an increased focus these days on fiduciary compliance for health and welfare plans. So we're going to spend some time talking about this required fiduciary certification and thinking about your fiduciary compliance in general. So beginning with the 2025 plan year, each written NQTL comparative analysis must include a certification by one or more named fiduciaries that they engaged in a prudent process to select one or more qualified service providers to perform and document the comparative analysis. And they've satisfied their duty to monitor those service providers as required under Part 4 of ERISA, which we're going to talk about in more detail. But I want to just highlight here, and hopefully, folks with fully insured plans may have joined this webinar unwillingly, but I promise that this is going to be important to you because this certification requirement applies both to self-funded and fully insured plans. So the mental health parity requirements generally apply both to group health plans and to health insurance issuers. So if you have a fully insured plan, your health insurance issuer is required under the law to provide these NQTL written comparative analyses. So you may not have thought much about this in the past because you may have said, oh, well, my insurance company has to do this. I don't have any of the information. I could probably just rely on them and their analyses. The problem with that for 2025 is that that written analysis must include this fiduciary certification. And your insurance company, I would bet dollars to donuts, is not going to provide a fiduciary certification and does not consider themselves to be a named fiduciary of your plan. Who is a named fiduciary? It's the fiduciary who's named in the plan, which makes sense if it's a named fiduciary, or one who, pursuant to a procedure specified in a plan, is identified as a fiduciary by the employer plan sponsor. Now, in many plans, if you open up the plan document and look to see who the fiduciary is, it will name the company, the plan sponsor, as the named fiduciary, which means unless that plan has a procedure for identifying other named fiduciaries, the board of directors of your company is the named fiduciary. And it would be the board of directors of your company who would have to submit this certification. That's probably not what you want. So note that fiduciary duties can be delegated, but of course, the fiduciary who does the delegation or the appointment also has a limited fiduciary duty to be prudent in selecting the fiduciary to whom they're delegating and to monitor the performance of the fiduciary. So when you're thinking about this certification, the first question you should ask yourself is, who is the right person in our organization to make this certification? Who can truly confirm that you followed a prudent process to select a qualified service provider and that you've appropriately monitored that service provider as required under ERISA? If it's not the board of directors, and if your plan says the company is the named fiduciary and your plan doesn't have a delegation process, you should think about amending your plan to identify the process by which that board is going to delegate named fiduciary duties such as this one. Prepare the formal delegation to the right person once that right person has been identified.
And when we're talking about, who's the appropriate fiduciary for this, I don't want to get people's hopes up. So you can delegate fiduciary duty. What we can tell you is that for those of you with self-insured plans, the TPAs are not going to accept fiduciary duty for this. So I don't see any world, at least in the near future, where you have a TPA agreeing that they will function as the named fiduciary for this purposes. They will sign on to the certification on your behalf.
But maybe if we all just push again and again and again and again, maybe they'll decide to accept it. But yeah, you're right. I would.
But not in the near future.
Not for 2025.
Yes. Mm-hmm. Okay, so then we get to the question of who is a qualified service provider, because once you've identified your fiduciary, they are going to need to make sure that a qualified service provider is conducting the analysis for you. We don't have a formal definition of qualified service provider in the regulations. We do have some informal guidance suggesting that, at the very least, your qualified service provider has to be someone who understands enough about the MAPIA requirements to actually prepare the analysis. If it's not going to be the entity that is actually designing and applying the NQTLs for your plan, then we think about, who do you retain, who's a qualified service provider who potentially will be able to get all of that information for you from the necessary parties, will be able to understand it, unpack it, and make sense of it for you.
The example that I heard informally from a Department of Labor representative was, my Uncle Joe, who runs a maintenance shop, is not going to be a qualified service provider, right?
Yeah.
They're not looking for a vendor who has been certified in MAPIA, right? They're just looking for somebody who knows enough about MAPIA to be able to do this well.
Okay, and so then we look at prudent process when you are selecting the qualified service provider. And again, when we talk about this concept of prudence, for those of you who attended our fiduciary webinar series earlier this year, we tried to drill in, it's process. So you don't always have to necessarily get the right answer, but you have to show that you engaged in a prudent process and you have to document that. So when choosing the entity who's going to function as your service provider to do the NQTL analysis, we think about, again, who developed the NQTLs? Would they be the proper party potentially to do this analysis for you? Would they be willing to do the analysis for you? who's administering the NQTLs for you. Hopefully, in most cases, that's going to be the same party, but sometimes it might not be. But you know, if you are using a third-party administrator for your self-insured plan and you don't have really any carve-outs, you know, you don't have a separate mental health, substance use disorder, or behavioral health carve-out vendor. The TPA is developing all the NQTLs, they're administering the NQTLs on your behalf. You haven't deviated from their standard plan design, then, you know, it might be prudent to basically use that TPA's standard non-quantitative treatment limitation analyses as your first stop. And maybe after evaluating it, you'll determine that that is sufficient, that it meets the requirements for your plan. But if you have a more complicated plan design, so let's say you potentially have carved out behavioral health TPA, or you have other sort of ancillary benefits that have been carved out, and you're going to need to look at the processes and procedures with which NQTLs are being applied on a more holistic basis across vendors. That might be a situation where just, you know, relying on your third-party administrators is not sufficient, and you might need to think about bringing in a third-party consultant who can pull all of those threads together for you.
And keep in mind that mental health parity analyses are done on a classification by classification basis. And so your classifications, again, are, you know, inpatient, in-network, inpatient, out-of-network, outpatient, in-network, outpatient, out-of-network, prescription drugs, and emergency, right? So if you have a carve-out PBM, that doesn't mean you can't use your TPA and PBM as the qualified service provider, because you're going to be analyzing the PBM's information separately from the TPA's information. It's where you're really carving out your behavioral health administration, because when you evaluate the mental health parity, what you have to do is look at the processes, the strategies, the factors, the evidentiary standards that went into developing and administering the NQTL for your mental health substance use disorder benefits, and compare that to what you used for the medical surgical. If you've got one TPA who's doing the medical surgical and a different TPA who's doing the mental health substance use disorder, they're not going to talk to each other. I mean, just realistically, they are not going to cooperate with each other to develop an NQTL analysis. And so relying on the TPA's standard NQTL analysis may not work for your plan, because you've got a different administrator with different NQTLs whose information is not being included in the analysis.
And keep in mind that even though, you know, we think probably generally you're pretty safe if you're relying on a carve-out PBM vendor because of that separate category, there can be situations where medications are administered under the medical portion of the plan. And in those cases, you know, depending on how much you're seeing under your plan, depending on what kind of NQTLs are being applied to medications administered by the medical TPA versus the PBM, you could have a situation where you need, you know, some coordination or some comparison between the two vendors.
And we had a question come in about, what if I have carved out our EAP from our self-insured plan? And that's an excellent question. Think about the EAP as something totally separate, as long as the EAP is not a gatekeeper. As long as you don't have to go through the EAP first in order to get coverage under the health plan, then we don't care about the EAP when it comes to mental health parity analysis. Granted, there are behavioral health benefits that can be provided through an EAP, but the EAP in most cases is going to be considered an accepted benefit under HIPAA, and HIPAA accepted benefits are not subject to the mental health parity rules. So again, so long as your EAP is an accepted benefit and is not used as a gatekeeper to get services under the medical, then it doesn't matter if you've carved out your EAP. And we had another question comes in, what if your TPA refuses to do this for you? We're going to talk about that later.
Yeah.
Because it is not going to be as easy as just asking questions of your TPA.
Mm-hmm. Okay, so how do you monitor the service provider? So once you've selected your service provider, you also have a fiduciary duty to monitor the service provider. And what I would say for this is that basically this is not just a select it and forget it process. You have to, take an active role in reviewing the analyses that you get from the service provider. You have to determine if you have the relevant expertise to be able to analyze the information that you've gotten from the service provider, to be able to flag potential issues, ask the right questions, etc. So, your named fiduciary might decide that even though their TPA is preparing the analyses for them, maybe they need to bring in some sort of consultant or third party, possibly a legal consultant, possibly a consultant with clinical expertise, to also review and maybe flag some areas where the analysis is lacking.
And before last Friday, I would have said to you, okay, you've got three options. Number one, you can do this yourself. The named fiduciary can try to review the NQTL analyses, ask appropriate questions to make sure the TPA did their job right, and then you're done. But fiduciaries are held to a prudent expert standard. Does your named fiduciary know enough to be able to read these, understand them, and evaluate them? Your named fiduciary most likely is not going to have the clinical expertise to be able to read this and say, yeah, that makes sense. I would have said that option two is, you engage your legal counsel to review the NQTL analyses. But the legal counsel also doesn't have the clinical expertise. And so while we may know more about what should be in the NQTL analysis, and we may be better able to develop questions than your named fiduciary, we still don't have the clinical expertise. So there's still something lacking there. And so option number three is to engage an independent vendor who has both the legal and the clinical expertise. And in my mind, it almost felt like we had to default to option three. I posed this to a Department of Labor representative last Friday, and she gave me some comfort on this and said, under the proposed regulations, you would have had to certify that the NQTL analysis was compliant with the requirements. Under the final requirements, we are just certifying to a prudent process and that we have engaged in monitoring. So your named fiduciary realistically could read the NQTL analyses themselves, ask appropriate questions, and you might not need to hire a third-party vendor to actually be prepared to make this certification. It's going to depend on, of course, the complexity of your plan and how many TPAs you have, and a variety of different things. But I'm not ruling out option one or option two anymore.
And so, questions to consider, and remember, the main takeaway here is you can't just ask your TPA for analyses, get their standard analyses, and say we're done. You have to actually review it, consider if it's sufficient. Key questions would be, did the TPA or the insurer provide written analyses for all of the plans and QTLs? So what we're oftentimes seeing is that sometimes these NQTL analyses will not address things like certain exclusions under the plan, which are considered NQTLs, not always addressed sufficiently in the analyses. Did they address the formulary under the prescription drug benefit? That in and of itself is an NQTL, and sometimes not specifically or directly addressed. Did the written analyses include all of the content required by the final regulations? I think this is sort of where we as attorneys can come in and help out and make sure that we're hitting on all of the points that are required to be included. Do the written analyses make sense? Can you understand what they are talking about when they're going through, here's what we relied upon, here are the outcomes that we looked at. Does this make sense to you? Do you have questions? Do you need to get somebody with a clinical background to help you to understand what's going on? And then do the written analyses include any of the deficiencies identified by the DOL? And on the next slide, we've listed a number of deficiencies. I'm not going to go through all of these in detail, but this would be something that you might want to look at when reviewing your NQTL analyses that you get. What I do want to do at this point is just go through a quick example that the DOL gave us that the tri-agencies gave us regarding a non-compliant NQTL. And I can talk about, what we see with this NQTL and maybe where, if we're preparing a written analysis, things might fall short. So in this example, we have a plan whose written terms include a step therapy protocol that requires participants who are prescribed certain drugs to try and fail a generic or preferred brand name drug before the plan will cover the drug originally prescribed by the participant's doctor. The plan provides an exception to that step therapy protocol. The exception was developed solely based on a methodology developed by an external third party. The third party's methodology is not based on generally recognized independent professional medical or clinical standards. So I'm not quite sure what they based it on, but we know that it's not based on generally recognized independent clinical standards. The methodology identifies instances in which a delay in treatment with a drug prescribed could result in either severe or irreversible consequences when we're dealing with a medical condition or a surgical procedure. To the contrary, when we're dealing with benefits related to a mental health condition or a substance use disorder, the third-party organization's methodology only identifies instances in which a delay could result in both severe and irreversible consequences. So what we see here is that they're applying the same step therapy protocol across medical, surgical, and mental health and substance use disorder, but the way that they are applying it is different. For medical surgical, they're looking for situations where not covering the prescribed drug could result in severe or irreversible consequences. For mental health substance use disorder, we have a higher bar. It has to result in severe and irreversible consequences. So that is an example of where NQTL can basically go off the rails as applied. So as written, it might look like it on its face is compliant, not resulting in a more restrictive treatment limitation for mental health substance use disorder. And if we were preparing a written analysis and all that was included in the written analyses was plan applies step therapy protocol, the plan relies on a third party to develop the methodology to apply the step therapy protocol, and the same methodology is applied for both mental health substance use disorder and medical surgical, but they don't get into deviations or nuances with respect to that protocol. That would be an example of where the written NQTL analysis is falling short because you're not providing enough information about how that methodology is actually applied.
And now you just scared everybody away from option one of having the beneficiary review and evaluate the NQTL analysis. So let's assume you're going to hire a third party to come in and either evaluate your TPA's analyses or provide the analyses themselves. Something we've seen is clients wanting to have the vendor send that deliverable to us so that they can claim attorney-client privilege. And I wanted to spend a minute to talk about this. If you are hiring a vendor to write the NQTL analyses, don't send them to us. I mean, please, I like to see them, but that's not going to protect attorney-client privilege because the NQTL written comparative analyses themselves are subject to disclosure to the Department of Labor and to participants and beneficiaries, as we're going to talk about in a minute. But if you're hiring a vendor to monitor your TPA's preparation of the analyses, and that vendor has some advice on, well, I think there are some issues here, or we see some problems here, you may not want that advice to be discoverable. You don't want somebody to be able to get something that says you have violated the mental health parity rules already, let's fix it. And if you're hiring a vendor, you might want to talk to them about how they provide the deliverable so it doesn't say you have violated the mental health parity rules. I mean, there's ways we can massage that message. But generally there is a fiduciary exception to the attorney-client privilege. So let's take an example. A client has engaged me as their legal counsel to help with mental health parity compliance. They have engaged vendor X to evaluate the service provider's NQTL analyses. Vendor X then sends their thoughts to me. What happens from this? Well, if we are obtaining this vendor's advice to advise the fiduciary in their role as monitoring the service provider, the attorney-client privilege isn't going to apply to a participant or beneficiary, unless and until that participant or beneficiary has an adverse interest to the plan. But just in general, they should be able to get that. Like, my advice to the client based on this analysis is, and including the deliverable, if I provide the deliverable, is going to be subject to discovery. But if, on the other hand, the vendor provides their analysis to me, I don't share that with the client, but I develop advice and recommendations to the client, then it's my advice and recommendations that would be discoverable in a fiduciary capacity. Theoretically, there might be an argument that what we're doing here is a settler function. The settler has to design the plan in a manner that complies with the law. We've hired the vendor to look at our plan design, which might include the way we deal with medical management or what have you. And then the vendor's advice to me, I provide advice to the client. That maybe is a settler function and settler advice, and it's protected under attorney-client privilege. But I think the chances of this information being protected under attorney-client privilege is slim. So if this is something you're concerned about, I think there are probably ways that you can talk to your vendor about how they deliver the message to you, ways about how your attorney then, deals with this information. I just want to make this a point to be aware of, that just because your vendor sends their report to me doesn't make it privileged under the attorney-client privilege. So what happens if we can't certify? Keeping in mind, this certification is something that must be included in the written NQTL analysis, which theoretically you must have in order to comply with the mental health parity rules, right? But there's always, I think in our area, the technical legal answer and the risk-based, business-based practical answer, right? The technical legal answer is, yes, you must have this in place by 1/1/25. The practical answer is, you can put the certification in the NQTL analysis when it's been requested. When are these things being requested? Well, they have to be provided to the DOL upon request. They have to be provided to participants and beneficiaries and their authorized representatives under ERISA 104(b)(4), which gives participants and beneficiaries the right to documents upon request. And you have to turn it over to a claimant requesting relevant information about a denied claim. So what happens if you get a DOL request? If you get a DOL request, you have 10 days, 10 business days to turn this thing over, which means you want to be in a place where you can make the certification, where you can get the NQTL analysis when you need it very, very quickly. If you don't provide it within 10 days, or if the DOL takes what you have and says this is, non-compliant, well, first, if you send something to them and they say we need follow-up information, they're going to give you 10 business days to provide that follow-up information. If they then make an initial determination of non-compliance, they're going to ask you to submit updated analyses, and you have 45 calendar days to turn that around. Ultimately, if you can't provide something to the Department of Labor that is compliant, then you have to notify your covered individuals, the Department of Labor, any service provider involved in the claims process, and any fiduciary responsible for deciding claims that your plan is out of compliance. And unless and until you provide updated NQTL analyses that are compliant, the DOL can tell you you can't apply that NQTL, which may require reprocessing of claims. This is a sort of worst case scenario, but I'm going to show you, I think the chances of you getting a DOL request are probably low. They are required to request at least 20 per year. In their first sort of reporting period on this, they requested 156. And by the way, don't catch my math here. This is not my math. I got these numbers from the reports to Congress. they don't add up. I know that. Please don't comment on it. But so the first year or the first period, they had 156. They're trying to go through them, and there is a lot of back and forth between the Department of Labor and the plan on this. So it took them a really long time. They were still going through many of them during the reporting period in the 2023 report to Congress. So you can see the number that they requested was significantly lower than it was the first time around. Generally, the Department of Labor is looking for red flags, and that's probably your best chance of getting a DOL request, is that if you have a big red flag, or you are a participant in a plan, or you have a plan that's being administered by a service provider that they're concerned about. According to the 2023 report to Congress, what they're trying to do, instead of requesting NQTL analyses from every single plan, is to use their resources to get the biggest bang for the buck. And so again, if there are complaints that are brought to them, if there are big red flags that are being waved, then they may come to you. But what they're trying to do behind the scenes is work with the TPAs, who they know are the ones that create the analyses, that run the analyses, right? We all know that that's where the compliance is going to come from reforming the TPAs. So they're working behind the scenes with the TPAs to correct issues that then will flow down to many, many plans. It's probably more likely that you're going to get a request for one of these from a plaintiff's attorney, because ERISA 104b4 requires disclosures to participants, beneficiaries, and a third party where the participant or beneficiary has authorized the release in writing. But if a participant has an attorney, you can't then go back to the participant and say, well, I need your authorization in writing. You have to recognize that attorney as the representative of the participant. And if you don't turn these over to the participant or their plaintiff's attorney within 30 days of a request, you could get penalties for up to $110 per day.
And Kim, I'm totally expecting that come 2025, we're going to be getting this as a line item in every single document request that comes through from an ERISA attorney.
Mm-hmm. Mm-hmm. And we've seen so many, it feels like the plaintiff's attorneys have been especially busy these days. Tobacco surcharge lawsuits that seem to come out every day, right? Lawsuits on discrimination, and mental health parity lawsuits have been going on forever. So this, like I said, I think is probably your biggest risk of needing to turn over these analyses. Now, if you don't turn it over to a claimant who's requesting it as part of their claim and appeal process, then we violated the claims and appeals process, and you're subject to de novo review in litigation.
So just a couple of additional updates. I'm not going to dwell on this, but we did get some clarification on the definitions of medical, surgical, and mental health substance use disorder. So one of the steps in the NQTL analysis is you have to basically identify whether you're treating something as a medical, surgical benefit or a mental health substance use disorder. Beginning with 2025, we need to be looking at the characterization of benefits in the most recent International Classification of Diseases and Diagnostic Statistical Manual of Mental Disorders. There are a few disorders that historically were sometimes classified as medical surgical that the DOL has basically said at this point, no, that's mental health substance use disorder, including autism, eating disorders, etc.
And way back when, there was a legitimate question about whether autism was a medical surgical benefit or a mental health benefit. If you are not classifying your as autism as a mental health benefit, you're at significant risk at this point.
Yes.
So action steps for 2025, Beth?
Yep. All right. So first on the list, we need you all to familiarize yourselves with common non-quantitative treatment limitations. Review your SPD to see what non-quantitative treatment limitations you can identify just through the SPD, and then talk to your TPA, your PBM, your insurer, to determine what they can provide you about NQTLs that they are applying that are not obvious from the plan design.
So after the proposed regs came out last year, and this was something we were looking at, we encouraged our clients to send a list of questions to their TPAs. And one of those questions was, would you provide us a list of your NQTLs? And we did not get good answers. In one case, the TPA said, Due to the manner in which NQTLs are defined, it is difficult to provide an exhaustive list of NQTLs that may apply to your plan. However, we have standard NQTLs and would apply to the extent you utilize our standard process. So there's one vendor saying, no, we're not going to give you a list of your NQTLs. We'll give you our standard list of NQTLs, but we're not guaranteeing that it applies to your plan. I had another vendor come back with a list of NQTLs, which did not include medical necessity, did not include experimental investigational, did not include formulary design, and this was a TPA with a carved-in pharmacy benefit. So I know that that list was insufficient. So while we are recommending that you ask your TPA for the list, you also have to supplement it with your own review based on what's in the SPD, looking at that list of NQTLs. Did your vendor identify all the ones that were on that list? If not, does your SPD confirm that you don't do it? So while having that information from the TPA is going to be helpful, there are additional steps you're going to need to take.
And unfortunately, in a lot of situations, you'll have to push for that information.
Yeah.
One thing I do want to call out at this point, we don't specifically have a slide addressing vendor contracts in this presentation. Anyone who's worked with Kim and I regularly know that we always push for mental health parity assistance language in vendor contracts to varying degrees of success. We've seen in the last couple of years some TPAs who basically will come back and say to us, we're not going to agree to help you identify non-standard NQTLs. That's your responsibility. What we will do is offer to assist you if you get a DOL request. At this point, that is, in my opinion, just patently not compliant. These NQTL analyses have to be done whether or not you get a DOL request. And so we need all the assistance we can get from the TPAs. And as a plan fiduciary, fiduciaries should not be agreeing to just getting the NQTL analyses or assistance upon a DOL request.
As we think about the fiduciary certification, figure out who are your named fiduciaries. Are they the right people to be able to make this certification? If not, as I mentioned before, consider formal delegations of authority and consider whether the plan needs to be amended to include a process for delegating.
Make sure that when you are going through selecting your service providers, that you're documenting the process that you engaged in to do so, that you're documenting the process that they engaged in to the extent you can get information about it, to do the comparative analysis. Consider how to monitor the qualified service providers. And we talked about this previously, so I'm not going to dwell on this, but as we've talked about, things like confirm that analyses were provided for all of the plans and QTLs. Don't forget operational compliance. So, even before we have the new, more explicit data analysis requirements kicking in for 2026, there still is currently a requirement to evaluate the NQTLs as applied. And so there might be some level of data analysis that needs to be included in NQTL analyses at this point.
And we did receive a question, is there a specific format or recommended language for the fiduciary certification? Not at this point. There's no model, nothing like that. I think you would simply, I would just copy and paste the language of the regulations, honestly, and say, yes, I engage in a prudent process to select qualified service provider, and I fulfilled my duty to monitor them. And then as we're thinking about the new or the updated definitions of mental health and substance use disorder, you just want to make sure that as your TPA is performing these analyses, that they are categorizing benefits as mental health or as medical surgical based on the DSM and ICD, and ensure that their QTL testing also reflects the definition. So we're not going to talk about QTL testing today, but this sort of aspect of the regulations is going to touch both NQTL and QTL. With that, we're going to bring Meredith back to tell us what we need to know for 2026.
Okay, so as mentioned earlier, one of the new requirements for the 2026 plan year is compliance with the meaningful benefit standard. So this means that if a plan provides any benefits for a mental health or substance use disorder condition in any classification, it must provide meaningful benefits in all classifications for which medical surgical benefits are provided. And this is determined in comparison to benefits provided for medical surgical benefits. So to be considered a meaningful benefit, the plan must cover a core treatment for each covered mental health substance use disorder condition in each classification in which the plan provides coverage for a core treatment for one or more medical surgical procedures.
So I think a concern here is, how are we going to know what the core treatments are? The Department of Labor has told us in preambles and right that ABA therapy is a core treatment for autism, that nutritional counseling is a core treatment for eating disorders. Now, they're not saying in this reg that we have to cover all of the core treatments. We have to cover a core treatment. But again, we don't have the clinical expertise. You don't have the clinical expertise. Who has the clinical expertise to understand whether the things that we've excluded are all the core treatments? Theoretically, that's the TPA. In that list of questions, we asked our clients to send to their TPAs after the proposed regulations. We included one that was, do we exclude core treatments for any of our mental health or substance use disorder conditions? And I didn't have a single TPA that wrote back and said, something definitive. Like, it was more just, we're not responsible for legal compliance, yada, yada.
We're not responsible for plan design.
Right.
Yes.
So I think here, if you have an exclusion, then I think you can look at that exclusion and say, is this a core treatment? And if my TPA won't tell me, or, we ask, so again, this fulfilling our fiduciary duty, we're asking questions of the TPA. Do we cover other core treatments? If they can't answer that, then I think we have to find somebody who can, unfortunately. And I'm never in favor of telling clients, you have to go out and have to hire a vendor. But I feel like in this space, we're going to eventually get to the point that we are in the 401k space, where every committee hires an outside independent investment advisor. We may get to the point where every welfare plan committee or fiduciary has to hire a mental health parity advisor. Hopefully we're not there yet, but keep that in mind as you're preparing for 2026, as you're thinking about plan design for 2026. And to be honest, I've seen a lot of SPDs these days that don't have exclusions for mental health or substance use disorder coverage. I mean, maybe through the NQTLs, experimental investigational medical necessity and so forth, but I'm not seeing a whole lot of specific exclusions for treatments these days. Oh, and so sorry, I just stepped all over
You're
you.
good. Another requirement effective for the 2026 plan year is that the final regulations prohibit plans from relying on discriminatory factors or evidentiary standards to design an NQTL. And so according to the Department of Labor, factor or standard is discriminatory if it's the evidence or standards on which it is based are biased or not objective in a way that discriminates against mental health substance use disorder benefits as compared to medical surgical benefits. So they're designed to disfavor medical or mental health benefits.
I like to refer to this as the garbage in, garbage out principle.
And again, how do you know?
Yeah.
How do you know without a clinical background whether any of the factors or evidentiary standards were discriminatory? And there is some detail in the regulations about this. But ultimately, again, I think it's going to be asking questions. Can you ask questions of your TPA to confirm that there's just, factors and evidentiary standards aren't discriminatory? And if you can't get an appropriate answer from your TPA and you don't know, we may have to hire a vendor who can tell us the answer. But again, as you're reading through the NQTL analyses, this is something to keep in mind, that although it's not, required yet, it will be for 2026. So I would just keep your antenna up for something like this as you're reviewing the NQTL analyses for this year.
And the final kind of key new requirement for 2026 plan year is that plans will be required to collect and evaluate data to assess the impact of NQTLs on access to mental health substance use disorder benefits. So they'll need to collect things like the number and percentage of denials, as well as any data required by state law or private accreditation standards. And if the evaluation they conduct suggests that the NQTL contributes to a material difference in access to mental health versus medical surgical benefits, that'll be a strong indicator of a parity violation, and plans will have to take action to address that violation and document any actions taken in their analyses.
So we had a question come in, what's the difference, if any, between the in-operation analysis requirement and the 2026 requirement relating to outcomes data. I would say the 2026 requirement is probably more instructions on how to do the in-operation analysis. So right now, you don't have to do the things that they're saying you have to do in 2026, but you have to evaluate in operation. So you may be doing the exact same thing now for the in-operation analysis and in 2026. I will say I have seen vendor reports doing in-operation analyses where they come back and they say, you know, the percentage of doctors within so many miles of your participants, you know, in-network doctors within so many miles of your participants' residence is X% for medical surgical. And if it is anything less on the mental health side, like a 0.1%, they flag that as not in parity. And I don't think that that's the case. I think if you look at those now, you don't necessarily have to consider that out of compliance in operation. Under these rules, that 0.1% definitely is not going to be an issue, because what they're looking at is a meaningful difference in access to benefits. So if it's 96% for medical surgical and 95.9% for mental health, that's not a concern. If it's 96 for medical surgical and it's 70% for mental health substance use disorder, then we have a concern. And we're not out of compliance. I think that's very important. And I like that aspect of these regulations. That doesn't mean we're out of compliance. That means you very well may be out of compliance and you need to take more action to understand. And if there is in fact a material difference, take action to address that difference.
And one of the other nice things about the new regulations is that they do clarify that there may be material differences in some cases. And if you can demonstrate that those material differences are not based on anything other than, for example, you know, methodology or factors that were developed based on independent professional, medical, or clinical standards, then it may be that even if there is a material difference, you're still in compliance.
Right, so just a general overview of thinking ahead for 2026. Ask your TPA, your PBM about those core treatments. If you see an exclusion in your plan, figure out, are you covering any other, is that a core treatment? Are you covering any other core treatments? If you're hiring a vendor to assist with NQTL analysis, ask them to think ahead to 2026, right? Will their review, because in 2026, the NQTL written comparative analyses are also going to have to address some of the 2026 requirements. So maybe they're willing to evaluate this for you now so that you know now whether you're already, you know, in or out of compliance for 2026. Ask your TPA, PBM insurer whether they're reviewing their NQTL analyses to confirm that no factors or evidence are discriminatory. And consider requesting and evaluating outcomes data now so that you can determine whether actions can be taken to avoid material differences in access in 2026. I will say if you are hiring a vendor to do this, maybe suggest a discount for multi-year analyses. If they're going to do something different for 2025 than they are for 2026, they may be willing to discount if you're willing to, you know, stick with them for a couple of years. So final thoughts, because I absolutely hate these rules. I hate talking to clients about them because I feel not empowered to help. I feel like my clients don't feel empowered to comply with these rules because we're so reliant on service providers that may or may not be forthcoming with the things that we need in order to get this compliance done. So let me just leave you with this statement that was in the last Department of Labor report to Congress. The comparative analyses are an opportunity for plans and issuers to think carefully and deeply about how they apply NQTLs to mental health substance use disorder benefits as compared to medical surgical benefits, either through a longstanding practice or a new limitation. So as you're pulling your hair out and you're stressed about dealing with all of this, you know, can I encourage you to look on the bright side for just a minute and say, we're doing a good thing for our participants. Like if we identify a problem and we can get our TPA to fix it, we are making life better for those of our participants who need access to mental health care, to substance use disorder care, and aren't getting it under the current design. So I don't know if that makes you feel any better or not, but I just thought I'd try to shed A little bit of light and give you a spoonful of sugar there. So with that, we have a few minutes left over and we've got a few questions. We can run through them. One question that we had is, what if you don't have a board? Thinking back to where I talked about the NQT or the fiduciary certification, and that if your plan says the company is the fiduciary, that would be the board. If you don't have a board, can it still be the company, or would it come down to the CHRO or benefits leader? It's my understanding, at least under Ohio corporate law, that every company has to have a board. So you should have a board of directors. If you don't, then maybe we need to talk corporate governance and maybe there's a different answer. But I think every company should have a board. And if your document names the company, the board of directors sort of is the default. Now, if the board of directors from a corporate governance perspective has given the CHRO authority to do certain things with the benefit plans, then I would ask you to check your plan document to see, is that delegation of authority, however they did it, consistent with the process that's identified in your plan. If not, that CHRO is not the named fiduciary and wouldn't be the one making this certification. Again, you certainly could amend your plan to reflect that process.
Yeah, the key is really going to be thinking about, because there, to the extent there are different corporate structures out there that companies could be operating under, you need to be thinking about, like, who is the top line. If your company is named as the fiduciary, the top line is going to be the fiduciary unless they've delegated that down. So, questions about corporate structure can be addressed, but that's what you need to be thinking about.
And I want to get back to the question of what happens if your TPA is non-compliant? Like, what happens if your TPA doesn't do this for you? Number one, can we hire a third-party vendor who then will go in and get the data from the TPA, and then the third-party vendor develops the analyses? I will say I have a short list of vendors who I have been told do this type of work. I don't know for sure that each of them does. I don't know how well they do them. I've only evaluated work product of one of them. If you all listening have recommendations for vendors who do this, if you would email us, that would be fantastic. We can add them to our list so we can help other people who ask the questions. If you want a list of the vendors that we have, knowing that I can't, vet any of them, email me. I'd be happy to send you our short list. So option number one is, can we get an independent vendor to do this for us if our TPAs aren't going to help? Number two, and maybe this should have been number one, right? Can you do it yourself based on what the TPA gives you, right? They might not give you the detailed NQTL analyses, but maybe they'll give you their standards and they'll help you figure out how your plan deviates from the standards. And then you could develop the list for yourself. But ultimately, if they're just not helpful, if you don't have a contract provision that allows you to push them to do this, you might have to think about finding a vendor who is helpful. Now, granted, I think many of the TPAs tend to be about the same when it comes to helpfulness here. Some may be slightly better than others, but that's a fiduciary decision to make.
And I just want to put in a plug here. We keep talking about, if your plan deviates from the standard. One thing you might want to think about at this point is, if your plan does deviate from the standard, why? And do you want to continue to deviate from the standard? Because I think sometimes these deviations are held over from decisions that were made years ago that, maybe there isn't a great justification for it now, and no one's significantly tied to maintaining that deviation.
We got a question about Alzheimer's, and to be fair, I don't actually know if Alzheimer's is a mental health or substance use disorder, mental health benefit. We would need to check the DSM to see if Alzheimer's is included in the DSM, then it would be a mental health benefit. What are the core treatments for Alzheimer's? I don't know. Again, I'm not the clinical expert.
Yeah, I was a psych major in college, but that was a good 20 plus years ago. So
I'm sorry, we can't give you a definitive answer there, but I would say if it's in the DSM, it's going to be a mental health benefit. And the biggest question that we get most often is, will the copy of the slides and a recording of the webinar be provided? Yes, that will be provided within 48 hours of the end of this webinar. So you should all get a copy of the slides and a copy of this recording. And that takes us to time. So just want to thank everyone for your involvement today. If you have questions we weren't able to address, email or call your regular Thompson Hine lawyer. If you're not a current Thompson Hine client, contact me and we can talk about options for addressing your needs. Thanks, everyone. Bye-bye.